Hello, and welcome back to Coin Lady channel. Now, a partnership between Visa and SWIFT has been established, with the goal of improving connection across networks in order to facilitate international business-to-business payments. This partnership would facilitate the worldwide movement of billions of dollars. Indeed, the companies will collaborate with the goal of giving banks and their clients additional options for cross-border money transfers, all while making such transactions faster and more transparent. Erica Losi, Chief Strategy Officer at SWIFT, and Chris Newkirk, Global Head of New Flows Commercial and Money Movement Solutions at Visa, were my guests earlier this week. I started by inquiring about the new partnership announcement with Chris, who I knew would have insight into the challenges that many companies still encounter. Our partnership unites two world-class companies and a suite of skills, and I couldn't be more thrilled to share the news with you. In the end, it will let us work together to enhance cross-border flows, making them more open, certain, and data-rich. This partnership is fantastic and fits in well with our network of networks approach, which aims to provide excellent client experiences by collaborating with various networks in addition to our own network. Judge Nat Byrne has granted the SEC's request for a complete compel, so we can now share some exciting news about the SEC's lawsuit against Ripple. We will examine the documents to confirm what is allowed and what Ripple is required to disclose, including the format of their financial statements. Given the decisions in the court's most recent filings in the case between the SEC and Ripple, it is quite unexpected that the SEC is receiving complete permission for their motion to compel. Nevertheless, with the assistance of Attorney Violin, we will thoroughly examine the paperwork in order to facilitate this discussion and ultimately assist you in leading a more fulfilling life. Videos here could cover topics like Bitcoin, personal finance, and investment. Breaking news was just announced a few seconds ago, so if you haven't clicked the button yet, you should. The relevant day, according to Judge Nat Byrne's viewpoint, is February 520-24. Ripple is being ordered by the Securities and Exchange Commission to provide consolidated financial statements for the years 2022 and 2023. Earnings from institutional XRP sales after the complaint was filed are subject to variation. 3 questions are both open-ended and need an answer. 2 of these inquiries are about the details of post-complaint contracts that govern institutional sales. The current round of Ripples is against the application. So, on July 13, 2023, the court considered the parties' cross motions for summary judgment, which are relevant to this matter. Remedy specifics pertaining to the court's decision that Ripple was involved in the illegal offering and sale of securities in breach of Section 5 of the Securities Act of 1933 have just been settled between the parties. Establishing timelines for such discoveries is reasonable, if you can believe it, when it made institutional sales of XRP to institutional purchasers. While she will address the earlier motion to compel that was filed more than 3 years ago, it pertained to experts and had no bearing on the financial papers in question or Ripple's participation in transactions subsequent to the complaint, hence, she will address it here. Considering the situation at hand. When deciding on an appropriate sentencing to assess the offender's conduct, the defendant's financial situation is an important consideration. Based on the facts of the case, the SEC reaches this conclusion without doubt. The purpose of requesting these financial information is to assist the court in formulating a workable strategy for finding an appropriate remedy. It is not asserting that it cannot afford to pay any fine. And since punishment is ultimately up to the discretion of the court. Without the ability to access such data. According to Ripple, the company's financial status is irrelevant to the decision the court will make, and the company does not anticipate a ruling that would significantly affect its financial status. Additionally, Ripple is adamant about keeping its financial disclosures under wraps. At this stage in the proceedings, the district judge, and not this court, will determine what considerations are acceptable and reasonable in order to determine what constitutes a sufficient remedy. The court finds no justification for impeding the inquiry by denying access to publicly accessible material that might be pertinent to it. For the years 2022 and 2023, Ripple must provide its financial reports. In accordance with the party that granted the protective order after the complaint contracts, the part about applying the remedy is where my response would end. Concerning the applicable remedy, the parties are at odds about whether post-complaint contracts are relevant. James Commission under the Securities Act, the District Court should investigate the District Court's post-complaint behavior, as CRS persuasively argues, while deciding whether an injunction is fair and suitable. According to Ripple's apparent, the SEC should be free to continue its post-complaint actions without an injunction. As a reply, contrary to what Ripple had claimed in its counterargument, the court is not convinced that creating these contracts would result in an unfair or costly mini-trial. The 3 XRP institutional sales revenues are due from Ripple when the company has produced its post-complaint contracts. Finally, any disgorgement estimate must include the proceeds from institutional transactions that occurred before the complaint was filed, according to the Securities and Exchange Commission. According to an alternative example cited in this article, the purchase of a security is considered to have occurred when the parties involved in a transaction enter into a binding agreement with each other. The relative importance of Ripple's response is not an issue in the present case before this court, due to the fact that the SEC has provided sufficient evidence to suggest that the court may benefit from this data while formulating its remedy. Ripple's disagrees with his legal statement, but the company maintains that no explicit or non-existent interactions were necessary for the parties to enter into its contracts. Instead, the contentious issue is whether Ripple should be required to respond to this question. In order for Ripple to comply with the ruling, it must respond to the interrogatory that the court allowed the Securities and Exchange Commission to serve one more interrogatory, and the request was fully authorized. Although the court clerk respectfully requested that the motion be denied, Judge Nett Byrne had previously given directives that were adverse to the SEC, and the SEC has been having some trouble with this matter. The financial statements, post-complaint contracts, and institutional sales revenues are all being turned over to the SEC by the court in this specific instance. We were hoping that the SEC would come out on top in this case, but guess what? Things have taken a surprising turn. Now that they've scored 3 things, they can go on with the remedies and maybe even get an injunction to get what they want. I hope we can find a solution soon, but these documents need to be processed and all that good stuff. So I was wondering if you think this will still have any merit and if the judge will rule in favor of the SAIC due to the items they will get their hands on and the potential higher penalties that would follow. So, we'll have to wait and see what happens. It's probable that most of it will be sealed. So, we won't be able to see Ripple's financial accounts directly, but maybe the discourse around them will provide light on what lies ahead. Once again, if we return to the beginning, this is a brief document, only 3 pages, and I'll provide a link to it below. Only 1 week from now, on February 12th, is the deadline for any of this finding. As a result, the schedule is still moving ahead. As we get through this stage, I'm hoping that we may see a little more activity here in the next weeks. I wish you a wonderful rest of the day and a great beginning to the week ahead. In the following one, we will meet again. Of course, I'm aiming to provide it to you ahead of schedule. I hope this was helpful to you. If you found anything useful on this website, please subscribe. See you soon, bye.